quorum of members present, I'll call the Public Health and Safety Committee meeting for Monday, October 24th, 2022 to order. The first item of business on our agenda for tonight is to approve the minutes of our previous meeting from 9/19 of 22, copies of which are in the packets. Any corrections or revisions necessary for the minutes that anyone noted? If not, I'll take a motion to approve the minutes. Motion by Henke, is there a second by McElhaney? Further discussion? Seeing none. Members in favor signify by saying aye. Aye. Opposed? None are opposed. Minutes are approved. Tonight, we've got a number of items on our agenda, and we will, because we have the budget session for the Finance Committee starting tonight at 6:30, we'll do a hard stop on this meeting at 6:20. That gives us an hour and 5 minutes to work through our agenda. I am going to reorder a little bit, though, to make sure that we get through the most important items for sure tonight. And then if we are efficient with that, we'll continue. But we'll potentially end up holding items 4, 5, 7, and 8 if we're short on time. So we've got item 1 taken care of. Item number 2 is the City of Wausau license policy presentation. Nate has got a PowerPoint to show us and some material to run through, just to do a little training and background on our process for screening, approving, and denying or recommending denial for municipal license applicants. We've had some questions on that lately, and there's some legal requirements that we and the applicants need to follow. And so Nate's going to walk us through that, and I'll turn it over to him.
Okay, yeah, so in 2016-17, we adopted a policy, and then, of course, the legislature changed a bunch of things, and then we had to amend our policy, and in 2018, this is now what it has been, and so then we adopted it in 2018. Now, I normally do not like reading word from word from a PowerPoint, but since this is so nuanced in the specific language in the statute, I'm basically going to be reading it word for word for it, because I don't want to misconstrue anything. Going off script could only just lead to even more confusion, because every time I'm presented with something I pull up the statute and just read it word for word, because it's the only way you're going to, I guess, know if we're in compliance or not. So obviously we have a couple of laws that we're looking at, and they kind of have to be taken into account at the same time. So we have the Wisconsin Fair Employment Act, and then Wisconsin Chapter 125 as a whole. And so that's what we're going to be balancing, and that's what our policy does. So first off, it is discrimination by a licensing board to prohibit licensing based on an arrest or a conviction record. A licensing agency would be us, a municipal government that is authorized to grant, deny, or renew licenses. That is the Public Health and Safety Committee that has been deemed by Wausau. And then looking into the Wisconsin Chapter 125, then that's when we can look at the arrest and conviction records only if they're substantially related to license activity. And we will get into what substantially related means further into the presentation. So Chapter 125 says that individuals, all partners in a partnership, officers, directors, agents, corporations, members, managers, agents, and the officers, directors, and agents of any nonprofit organization may not have an arrest or conviction record, may not be a habitual law offender, and may not be convicted of a felony which substantially relates to the alcohol beverage licensing activity. And so this is what we have to look at when we're looking at granting licenses. And now this part obviously is for the alcohol beverage licenses, but the policy will get further into the taxi cab license and other licenses that are not related to alcohol, but what we still grant or deny. So going into pending charges, because obviously we have conviction records and we have pending I don't want to say records, pending charges. So a pending charge cannot be taken into account, again, unless the circumstance of the charge substantially relates to the circumstances of the license activity and the charges for one of the certain specified crimes against a child or life and bodily security or a violent crime against a child. And I'll show you what those statutes are in just a moment as well. But it's mainly the 948s, the statutes in 948, like sexual assault of a child, repeated acts of a sexual assault, physical abuse, sexual exploitation, trafficking of a child, incest with a child. I mean, you kind of get the picture, but that's what those ones are concerning. Same thing with its discrimination if we refuse a license based on an individual who is adjudicated delinquent under the Juvenile Justice Code, again, unless the offense was for a certain specified crime against a child or life and bodily security. So again, those 948 statutes. And then evidence of rehabilitation. So Nate, what's evidence of rehabilitation? Well, I'm glad you asked because here they are. So our policy, we outline a number of things, and in the statute as well, there's specific ones. The ones in the statute that are specific are, which is the next slide, it's basically your honorable discharge, which is specific paperwork from the military, other documents as well that are described in the statutes are evidence of completion of probation, extended supervision, parole, things like that that you would get from your parole officer. But more of the, I guess, the everyday, I want to say fuzzy feeling things, rehabilitation evidence that we look at. Is the evidence of the nature and seriousness of any offense, circumstances or relative to the offense, like mitigating circumstances, social conditions, the age of the individual at the time, the length of time that has elapsed, letters of reference by person that has close contact with this person in the recent months, and then also in our policy, we have a kind of a very general overcatching statement of all other relevant evidence of rehabilitation, present fitness presented. That again is then for the chief to first take a look at. He then presents his recommendation of denial or granting, and then we as then the committee, either take that or don't take it. But in the highlighted part in the next slide, if they show competent evidence of sufficient rehabilitation and fitness to perform the license activity, here we're mostly talking about bartending, the license may not be refused or terminated based upon that conviction or convictions. So in other words, if there is, for one of the statutory rehabilitation evidences of the honorable discharge or something like that, basically discretion goes out the window and we have to then grant that license.
So I guess just as a practical example, and we've had experience in the committee with evidence of rehabilitation, but our experience is that evidence of rehabilitation is documents. It's not a story that a person tells you. It's not someone comes in and says, I'm really doing a better job now, or I'm trying to do a better job now. It's not a narrative, right? It's paperwork.
Correct.
That
Yep.
they submit to the staff before we ever get it here. So, if there's a recommendation for denial and the chief calls up and says, hey, applicant, you're recommended for denial, and they say, wait, I have these documents. He gets the documents
Yep.
to review, right? So that's a process that's happening before it gets to committee versus a narrative that a person would just tell you or tell us.
And our policy lays out that, yes, all that evidence should be presented to the chief to form his initial recommendation. If it were to be presented to our committee for the first time and the chief has not had a chance to look at it, our policy then dictates that basically that needs to be put on hold. The chief needs to go back, relook at everything, take that into consideration, and then give his new, amended recommendation, if that's what you want to call it.
Okay.
But yes, you are correct. It is not it's not a story for us to be told from here at the hearing. The committee meeting. It's supposed to be basically documents or specific acts that, again, are documented by either the person or somebody close to them, such as maybe probably not even family related. We haven't described in our policy who those documents need to come from, but probably somebody from a very neutral third party and maybe in a professional setting.
Well, and I think we've
to do
received
that.
them before from probation and parole staff. We've received them from employers. I think we've received them from counselors before. It's not very often because not a lot of recommended denial applicants have paperwork, but when they bring us paperwork, it's that type of document that we've seen. It's not verbal. So.
And then, so I guess to then segue into the last highlighted part, if there is no rehabilitation evidence provided, it is presumed that it does not exist. It is not our job to think, well, there could be a discharge letter, or there could be, 5 letters of recommendation that say this person is Gandhi. If it's not there, it's not there, and it's not our position to guess at what potentially could be there.
Okay.
So, and then there's a term called exempt offenses, and it's really a terrible terminology, and it's very confusing because when you think of something that's exempt, you think, oh, it doesn't apply. But actually, when you have an exempt offense, which is the charges followed here in 940, which are, the very serious ones.
It's the worst of the worst, pretty much.
Yeah.
Yeah.
That means then there's even less discretion, almost no discretion, and then for what needs to be then informed to the person that was applying for the license also does not apply. If there's an exempt offense on that person's conviction record, that's it. There is no discretion for us to grant it. There's no evidence of rehabilitation that can rehabilitate an exempt offense offender. That is it. In our terms, we usually call it like strict liability. If it happens, and it is what it is.
So, and that I think really is kind of where, in the past, we've had situations where, we've had a couple of applicants that I can recall in prior years where some of this stuff existed on the record, and yet a discussion began on the council floor where, the applicant came in and they told a story, that this is the only job they could ever have, and they're, going to starve if we don't have this license and whatnot. And they captured the emotion of that particular council, and were then the committee and the chief's recommendations, and I think maybe it was the prior police chief's recommendations, but those recommendations were overridden and a license got given out. And so this stuff being the most serious violations, when this stuff is on the record, it's just flat out no license, right? I mean, we don't have the ability to, I guess, feel sorry for the applicant and award the license. And so, that's the kind of stuff that we have to watch for. And, at that point, then the storytelling stops when it's this stuff, right? So,
Yeah.
Okay.
I mean, at that point, not to say they're wasting their breath, but there is nothing that we can do. We would be then in a violation for granting a license for an exempt offense offender.
Well, and I think when we had some discussion on the council floor, when we had some question about this, we had talked about, both the city attorney and I both talked about the fact that if we don't handle people consistently, that opens up an opportunity for liability against the city for treating people disparately and not consistently. But then it also, if you grant a license under these circumstances, then also, I think if something happens in the use or the discharge of that license, we have a problem there as well, right?
Yeah.
So and I think that's where our need for the training today came up, because we've had an awful lot of discussion about, well, it's someone's livelihood and you have to give second chances. And for all of us who would want to, there's times that you just can't. So I think that's where, we need you to set us on the right
Yeah.
path.
And that's the purpose of the policy, is that, we try to take into, considerations, and that's why there is the evidence of rehabilitation. It just needs to be documented. It just can't be off the wall commentary by the person while they're here. The policy is to ensure that we are consistent with everybody, regardless of any of the protected classes. I mean, at the end of the day, it doesn't matter who you are or anything like that. It's just, what does the conviction record say? What are you applying for? It's almost like a checkbox with our policy. Yep, if you meet this, this, and this, sorry, you don't get a license. We're not saying that you can't get a job anywhere. We're just saying you can't get a bartender or a taxi cab license.
Well, and in the bartender situation, it's not even that they can't work there, they just can't work there unattended. Like, another licensed person would have to supervise that person. So it's not like if someone can't get a bartender's license, they're automatically out of work. It's just inconvenient for the employer because they can't leave that person in charge of the place unattended. So, and I think sometimes when that's a convenience store and they're short on staff to start with, they run into troubles with that. And, same thing with taverns. If they're not flush with workers, they want to be able to leave anybody and everybody alone there and assume that they're all licensed. Well, I think that's where, there may be some misunderstanding that that person automatically has to be fired. Well, they don't. They just shouldn't be working unattended. And there's a reason for that, because the record has called into question either the prior actions or perhaps the trustworthiness of that person's conduct.
Yeah.
In regard to the relevant activity, right?
Yeah,
So-
and then and then that's a great segue into the substantially related, which we'll touch on in just 2 more slides.
Okay.
Yeah, Doug, did you have?
Oh, sure. I have a question regarding
ahead.
this, because we spent quite a bit of time talking about not allowing exempt individuals from getting license. Have we looked at any of those since this board has met, or since this council has met?
The recommendation at the last meeting, if I recall correctly, there was a battery charge, if I think my memory is serving me correctly. I'd have to look at the minutes, but I believe there was a battery. And so that is an exempt offense under 940, 20 to, or 20 to 20, I mean, yeah, I guess starting at 19 to 208, or are the battery charges.
Typically, when I send a letter out for a denial, it's two different letters. If there is an exempt offense, I mean, Ben usually flags it to me, and then that letter doesn't get the page that tells you all the rehabilitation documentation. It just says, this is an exempt offense. It still tells when the meeting is, because I guess that we have to do, but they don't get the same letter telling them what they need to do to appeal it.
Okay, because I've recommended we hear some people's input or their cases, but it wasn't brought to our attention that there was an exempt case on their file, and if so, that changes the calculus, certainly.
Yeah, and like I said, it's a terrible word. I wish they would not call it exempt offenses, because to me, it sounds, again, like,
Like
oh, you
that makes
murdered.
it okay.
Yeah, oh, you
It's the
murdered
opposite.
somebody? Oh, that's exempt.
But my question is, have we considered any with exempt cases
Yeah.
in recent?
So last meeting, there was a
Yeah.
battery.
Yep,
Okay.
and prior to that, on two other occasions, back when Chief Hardell was the chief, there was one license that was recommended for denial by Public Health and Safety. The council overrode him and the committee, and I believe they gave a license to a felon. So, I mean, big mistakes can happen on the council floor when we let emotion make our decisions for us, and that's what I was trying to tell us at council, is that we can get ourselves into some tough sledding if we, get away from the criteria, because not only do we render the criteria moot, but then we also open up some legal hurdles for ourselves. So, and I think there was one other one where the committee or the council, one or the other, decided that they wanted to give a person a one-year trial. Well, really is no such thing. If you give it, they have it, and then you renew it, and it puts, the onus on Mary to say, well, geez, this one was a one-year trial. Well, that really isn't fair to the clerks either, to make sure that they're watching certain people, so.
Yeah, and then revoking a license, as we talked about previously, is much harder than denying from the get-go.
Correct.
I mean, obviously, you can't discriminate from the get-go, but once a person has a license, there are way more hurdles to jump through, and when we ever have another alcohol license revocation hearing, you will then understand what it all takes.
Yeah.
And can I just clarify too? I want to make sure I understand what you're saying, which is if you give a license kind of as the trial idea, now they have a license, and whether or not you want to revoke or even non-renew, you have to go through that process. You can't just not renew them. You have to go through the formal revocation
Non-renewal.
process, non-renewal process,
Right.
and show evidence why they should be non-renewed.
And it's a quasi-judicial hearing, and you have court
Right.
reporters and attorneys, and you have, it's a lot. I mean, it's hours and hours of meeting time for everyone involved. So it's when I say tough sledding, I'm really not kidding. Doug?
So is there, do you have a rough idea percentage-wise of the number of denials based on exempt offenses, or do we have a lot that fall, I would assume there's a lot that fall well under the exempt status that we could be talking about. I mean, we're talking.
I mean, Mary could probably give you a much better idea. I can tell you that the vast majority of license applications that I look at get approved.
Yes.
The vast majority, probably 90% or more. And then of those that are denied, I don't know what the mix would be in terms of exempt versus non-exempt. I'm not sure. Most of them would be exempt, I would say, probably.
And if
but-
you look at, when I send you the record in the PDF, when I send an email, if Ben says it was an exempt offense, it says that in the letter, if you look closely at the letter for the reason for denial. And I usually put it too in that clerk's report that gives additional information about a denial. I'll say if it's exempt or not.
But also when there's stuff on the record that we are not privy to see, like some of them have a criminal record that Ben can see, but we can't. You also tell us that, right? So at that point, we then have to trust his recommendation. We
Right.
don't get an airing of someone's full criminal history in a public meeting packet, but.
Right, what I'm sending you guys is only CCAP, which is public record, because the other record I check is the criminal justice system, and sometimes that has a lot more, but because we pay for that, I can't send that out in email. So the only one that gets to see it is Ben. So he's really seeing more than what you're seeing.
Well, and that always has kind of always been my guiding force with trying to make the decision is when we ask him, you know, he'll hear from the person, does anything change your recommendation? And if he says no, I mean, there's times he said yes before, but there's other times where when he says no, chances are it's because he has either seen or been privy to more information than us. And so, you know, we put a lot of weight on their recommendation, and they don't take that assignment lightly. So I think that's helpful to us to know, like, you know, when there's stuff that we haven't seen in the packet. Go ahead, Nate.
And then this is more continued exempt offenses, and these are those 948 child-related crimes that we were talking about previously. So all those are also exempt offenses. There's also then special alcohol provisions, and that's what these ones are with the statute. So basically anything dealing with manufacturing, distributing, delivering, possessing controlled substances. So basically any of those, if the person has a conviction record of that, there is non-employment discrimination if we deny just based on having one of those on their record. And that's just this for the alcohol licenses. Now here's where we are to the substantially related. So in the policy, somebody went through, and this was before I was here, okay, what do we consider as Wausau? What is substantially related? Because the statutes and case law, they don't say what substantially related means. They leave that up to us to figure that out. So we've broken it down into a couple of categories of certain alcohol, drug-related offenses, felony offenses involving bodily security, and then just other felony drug offenses. So for the first one, so we're looking at alcohol and drug-related offenses. We've said, you know, manager or bartender, they're required to exercise responsibility and good judgment with selling alcohol to make sure, you know, underage people aren't served, patrons aren't overserved. If there's a disorderly incident at the bar, you know, they alert police to that situation, observing some closing hours, because, you know, there is the very hard rule of bar close. Nobody can be in the premise after bar close.
Well, in those four, you know, you'll see a common thread there. Those four, underage, overserved, alerting the police or failing to, and observing closing hours, all of those things coincidentally involve points on the license. So when that stuff happens and the person in charge didn't do the right thing, the owner is getting demerit points
Yep.
for that.
Yep. It's as you can tell, this is a Wausau policy to then work with our other Wausau policy of the demerit point system. It's like we planned it. So, because again, we're saying that these are substantially related because, you know, the felony and habitual alcohol-related offenses, they demonstrate certain tendencies and inclinations with respect to a lack of judgment, poor judgment, or self-control with drugs and alcohol as themselves, and then that's likely to reappear later when they are supposed to be either supervising or serving alcoholic beverages. And so for these types of offenses, I guess the policy is that 2 convictions within 5 years or 3 convictions within 10 years of the submission of the application for OWI PAC, which is prohibited alcohol content, which is basically OWI, or the misdemeanor possession or attempt possession of a controlled substance. Those are what we're looking at, that if you have one of those or both or all 3, those are substantially related to bartending or managing a bar. Then going on to the felony offenses involving bodily security, again.
Quick question on that.
Sure.
If they're substantially related and they show proof of rehabilitation, is that where the rehabilitation comes in?
Yep, as long as, again, that it's not exempt offense. So because, again, you cannot, it's considered discrimination if you deny a license because they have, you know, a conviction. But if it's substantially related, then we can then take into account then that conviction for that license. If they then provide evidence of rehabilitation and it's not an exempt offense, then yeah. And if it's sufficient to, I guess, this committee of, if it's rehabilitating enough, then yeah, then that's okay. And again, that's why we have that evidence of rehabilitation, so it does give the person, you know, a chance to apply as long as it's not an exempt offense.
Nate, I've got one here.
Oh,
go
So part of rehab, it would be time since last offense, I would assume is part of the calculation in this 2 consecutive within 5 or 3 within 10.
Yeah, so, and I kind of wish the other ones had some sort of, criteria, because again, I just like objective check marks, to say, yep, this person's got, they're on their second OWI within 5 years. Oh, okay, well, our policy says that, it's a denial. So,
Well, one of the
so
issues we
with
have.
that,
Yeah.
so with that, I think I can see what you're saying. So one of the things is a rehabilitation. Well, we'll say, okay, well, it's been 5 years. Well, yeah, it's been 5 years, but our policy here says if there's 2 within 5 years, then that's considered substantially related, and the application should be denied. If it was 6 years and 2 convictions, then I think then that evidence then can come in. Does that make sense?
Sure. So there is I'm looking at some things here recently that were from 2007, and I really, in my mind, kind of discount those for consideration. But the wording here says convictions, and in the last time we looked at, somebody had some incidents that were 3+ years ago, but the conviction didn't come until, because of the backlog in the judicial system, until recently. So they really got 5 years plus the 3 years it took to get to court. I mean, it's a
Yeah, and that's
substantial burden.
Yeah, and that's I want to say, kind of a black sheep because of the COVID.
It's kind of a pitfall of the
Yeah.
delay. I mean, ordinarily,
Yeah.
if the court system were on
yeah.
time.
Normally, it's not that delayed, but because of COVID, courts are shut down for quite a long time, and then now there's the backlog. Well, now I guess we're getting through it now, but the backlog then at the beginning was horrendous. So I'm hoping we are past that. I'm not saying we're not going to see any more that are like that, but that delay going forward, as long as we don't have any more pandemics, should
But
not.
potentially, if we were to take something into consideration, that could be a mitigating
Yeah,
circumstance.
it was definitely something that should be noted, and that you would want to think about of when did this happen, and when it was convicted.
Well, and I think I will say that, at least from experience prior to the pandemic and the large court backlog, we didn't have that problem. I mean, usually unadjudicated violations where people were awaiting trial, or they were, it was fresh stuff that had just happened within the last, there was a number of months. It wasn't 2-3 years ago. It was, things that maybe had happened at, the end of last year, and they were working their way through a process, but it wasn't years old.
And I would just say one thing, just to make sure clear on how I view the policy and how I'm executing it, at least. So if I need to change that, you can tell me. But if there is somebody that has 2 convictions of OWI, and one of those convictions is outside of 5 years, so you don't have 2 within 5, but you have 2 within 6, I would approve that application. So you wouldn't even see that. So the only time that you would need, that you would possibly see somebody apply with evidence of rehabilitation would be if they have 2 within 5 or 3 within 10. And then you might see somebody submit an evidence of rehabilitation for me to consider, and then if I still deny, then for you guys to consider here. And that's, I think, I just want to clarify that that's how I'm executing the policy right now. So you wouldn't even see something like that for somebody that has 2 within 6.
And also, just to point out too, that you're also looking at, I guess, the totality of the entire conviction record. So, I mean, yeah, if the one person has 2 OWIs in a 6-year period, but then they also have, another felony drug offense or something like that, just because they don't meet it in the 6-year thing because of the OWI, there might be other record or other convictions on their record that might then put them back into the denial pool.
Right.
Definitely. It's a little bit of an art, right,
Yeah.
to your point. I mean, every criminal conviction history is different, so I'm going to look at the policy and try and weigh and see. I'm going to try and look at it through what I hear the folks on this committee saying, and try to make the best decision I can so that you don't have to see things that you question when you come here.
Well,
But
and so when
it
you
is a
get to
little
the
bit of an art.
5-year, 10-year screening process, and then you see there's lots of other things that have happened, either in between or in addition, things that indicate stuff like habitual criminality, and, a lot of other, like every year, something is happening. That really, I think, is when we talk about the totality, right? Where it's not like a couple of bad things happened and things just like time has cured it, other stuff has continued to pile on, right? So, that's at least the ones that we see often on appeal. That really is what the CCAP even looks like for us, is that there's an awful lot of just stuff out there. Often drug-related is what we've been seeing where, it will be, it'll be, possession or intent to deliver or sale, and then there's, other things, and then the alcohol stuff plays in. And so that sometimes is when it gets a little murky, because sometimes the drug stuff can be older. And so the applicant will come in and say, well, 10 years ago, I hung out with some really bad folks, and I've changed my group of friends. Well, it's okay, but then you're still within this criteria where, great that they've made changes, but are those changes recent enough that we still worry about being in control of a premises alone? Because then does this other stuff start to happen? And, I had someone once after a denial, a bar owner ask me once, well, what are you guys afraid of? And I said, well, it's not just that first, as a licensed bar owner, we worry for them. Like, we want to make sure that they have responsible people in charge because their license is their livelihood, and it's everyone else that works there's employment. And so we don't want to get in a position where somebody's allowing things to happen that's causing demerits, and then all of a sudden we're in suspension and revocation territory with a bar because they've left the wrong person in charge. In fact, we revoked one, and during the hearing, the owner blamed almost everything on the manager. So it happens. So it's protection for them. But then it's also, when you look at things on the record like alcohol and drugs, it isn't just even to protect the patrons. I mean, we don't always assume that the bartender would necessarily be the person that is coercing bad behavior, but that's a very tempting environment to work in. So for people that have had issues with substance in the past, and then you work in that environment, the patrons can tempt those folks to get back into routines that they don't want to get. Take a shot with me. Or let's shake dice for shots. Bartenders do that all the time. And if that person has a long alcohol history, they could be right back down the rabbit hole. And I think that's some of the things that we also weigh in our mind is like when you leave that person in charge, then now say that happens and, the place is busy. Do they not recognize a fight that's about to start? Do they not recognize somebody going out the door with a cup of whatever? It leads to other things. And so we've had a lot of those, discussions offline even with, bar owners and declined applicants. Like, why is this a big deal? Well, it gets to be a big deal, I guess. And so that's kind of where we have come at it before.
Yeah. And then as a bartender or manager, obviously the clientele that they will be dealing with in the state that those people are in, they need to exercise, good judgment, level-headedness, and patience dealing with these individuals. If they have a history of, violent offenses of, physical harm or serious disregard of rights for other people, that's when, again, it's a kind of a red flag and a more likelihood to then deny that license because, again, they show that they don't have the self-control and the patience, the lack of judgment, avoidance of force to deal with the people then that they will be potentially serving. Then going on to the last slide is then the felony drug offenses, which, again, is kind of saying the same things that the past two slides were saying, but again, they have to exercise good responsibility and good judgment to, again, ensure underage individuals are not overserved or not served. People aren't overserved, alerting police to disorderly incidents and observance in closing hours. So again, the felony drug and habitual offenses just shows, that they have this lack of judgment, poor judgment, or self-control. And then again, them being in that context might, as Lisa was saying, they might go back down that rabbit hole. And so that's what then we've said is substantially related for the felony drug offenses related to our licenses. And so that is the end of the PowerPoint. And so really I want to just leave you with consistency is the key. And we have the policy to help us maintain objective, consistent results. As soon as we start going away from those, then we're just, I guess, opening ourselves up to liability for anybody in the past that we denied. Yes, each case is a case-by-case basis, but at the end of the day, there could be two people that have, 2 OWIs in the 5 years, and if we approve one and we don't approve the other, and we can't explain why, other than the fact that they came in with a better story, that's not good enough, and we will lose that any day in court. For a discrimination suit. Once we set a bad precedent in a past practice, that's what's going to be, any court would then hold their hat on and hold us to. So the policy is there for what it is, and it was, I guess, to me, well thought out of to allow, people to have their second chances. When you're on your sixth OWI, you've had six chances again. So that's what that is. It might be the prosecutor and me talking, but
Well,
that's
sometimes though,
where
and
I'm at.
I guess I'll say, like, when you talk about the fact that, obviously people want to work and they want to turn their lives around, and it does feel good to say yes and give people second chances. But by the same token, we have to recognize also the list of choices that is in front of us, that these are choices that people have made. And sometimes choices in the past take time to resolve, but then also often, sometimes the narrative that comes out in our discussion with applicants is, that narrative is like, that's the only job that's out there. That's the only job. And, I got some advice once from a former chair of this committee when I first started on the council, and said, first, don't ever assume that an alcohol-related job or a taxi driving job or whatever that job is, that is not the only job that that person is capable of doing. And so that helped me look at things through a different lens. Now we know that with the job market we have locally, and I think nationwide, jobs are way more readily available than they were perhaps in 2008 when we were at the cusp of the Great Recession. But that was just some advice that she gave me, and she said, don't get lost in the notion that the job that you're considering the person for is all they're capable of. People are capable of many amazing things that don't necessarily involve environments that are serving substances. And I'm like, okay, well, sometimes I have to remind myself of that. When I read these records and you hear the stories and we take testimony, it doesn't feel good to deny. But there's times that I feel like we just have to. So does anybody have questions for either Chief Bliven or Nate about the process that we've been following? Doug, go ahead.
Yeah, so I guess because I was one who probably pushed back on this a little bit, so I want to understand. I'm not advocating that we try to circumvent exempt offenses under the state statute. But we have letters from to speak to what Chair Rasmussen said, I would agree with most of what you said, but you also indicated we should be protecting the establishment owner. And that's completely not what we're here for. We're taking rehab advice potentially from employers and the letters that they are vouching for these people. They've done their vetting, they want to hire them. So I think
Well-
that's not our charge, but I
No,
would like
but-
to figure out what the reason for the in-person. If somebody comes in to give a statement and wants to defend themselves, I think we should listen to that, and we should adjudicate those separately as much as possible within the law.
Well, I will say that just based on what we see in the committee, almost none come with written evidence of rehabilitation. In the last 15 years, maybe I can count them on one hand, 2 or 3 people literally out of all the denials. I mean, every month there's 1 or 2, almost 0 come with written evidence of rehabilitation. It's always a narrative and it's always a story. Sometimes it's the employer standing there also telling the same story, but nobody brings us documents. I mean, very, 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 very few.
So why do we have them come in at all then?
We have to, because under our ordinance, they're allowed to appeal, and they're allowed to address the committee and the council when they're recommended for denial. So it's a part of due process. But
Okay, so then at some level, we have some discretion.
within the guardrails that Nate just described.
I understand that, and I'm not
Yeah.
advocating circumventing state statutes, but there are, all right,
I
I'll
feel
leave it
like,
at that.
I feel like the the leeway actually rests more with the chief than with us. I mean, they get the right to come and address us about why they may disagree with his recommendation. Sometimes, and the question you'll hear that I ask most of them or all of them is there anything on your record that's factually inaccurate? Because sometimes stuff gets left on people's records that maybe isn't, maybe you get 2 people with the same name, or maybe there's an error in the record. And if something is factually wrong in the record, we absolutely want to know that. So that's always question number 1 is your record, the way we see it here, really your record? And I've not had anyone tell me no. I've had people tell me there was unresolved stuff that they have court dates coming for, and our request then always is that they let that play out. And if that takes care of itself and they are not then, guilty of those offenses, come on back in and reapply. You know that they can reapply at any time. A denial doesn't mean that they're restricted from applying in they can't apply again for a year or whatever. They can apply anytime. So if something gets taken care of in court in 3 months and it's in their favor, come on back, because chances are our decision might be different. But, we need to, we've been very cautious about following the criteria. I think that's, it just depends. Every applicant's tale is different, I guess. Anybody else have questions for either Ben or Nate? And we did invite the rest of the council to attend with us tonight or to watch the meeting on live stream or on YouTube, just so that they can understand this material the way we understand this material. Because sometimes even the discussion or disagreement or back and forth that we have here amongst ourselves plays out at the council level, and they often don't have, I haven't seen the meeting. And, sometimes the minutes are pretty detailed, but they're not word for word minutes. And I think they miss some of the back and forth and the dialogue, and, they don't get to have the interaction with the chief that we have here. I always feel like when we make a recommendation, after he and we have made a recommendation, we've seen more than the rest of our peers on the council have seen just by this process. So, okay. Anyone else have anything on that? If not, we'll put that issue to bed, that addition item to bed. And so what we have next on our agenda is item 3, consider approval or denial of various license applications. We have a batch of them tonight. We have one recommended for denial tonight, which is Cherish Winfrey. And our ordinance allows her to address the committee if she wishes. Is Cherish with us this evening? Cherish, you come on up to the microphone if you like. State your name and address for the record. And, talk with us about the record. Obviously, the chief has recommended denial in your case.
Cherish Winfrey, 3633 North 6th Street, Apartment 7, Wausau, Wisconsin, 54403.
So is there anything on your record that's not accurate first?
No, it's all accurate.
Okay. And so, I guess talk with us a little bit about, your disagreement with the chief's recommendation. I know that in this particular case, I think in our email that we got from Mary, there were items on the record that we've not seen. So, but I believe the chief has seen them. So, what has changed, I guess?
Well, basically everything from, excuse me. First, I didn't know I had to bring anything like rehabilitation, anything. I just got the paper stating that it was going to be a meeting here and I could come and talk about the denial letter or whatever. So I would have brung that, and I would have brung friends that could have vouched for me how I live now. My case from 2012, that happened, from 2008. That was back when I was like 17 or 18. Not to say it because I heard you say it, but I was with the wrong people, a boyfriend that I was dealing with when I was staying here, trying to be growner than what I was, and stuff happened, and I caught a drug case, and instead of telling, I called myself trying to be this girlfriend that, so I went through the process of messing my life up. It was 16. I see on the paper it said 2017, but I don't remember the retail theft being 17 because I was pregnant, but I was with someone. I was at Walmart and I was getting milk for my baby, and the person that asked me to take them to Walmart, because I wasn't going to go, I was going to wait till the next day to go get the milk, but this person that stayed in the building behind me, I talked to regularly, it was a family, and she asked me if I could take her guy to Walmart, and I took him to Walmart, ended up getting my son milk, and this person was stealing. So, as we leaving, needless to say, the police contacted me, and I did take the police to the person's house who I took to Walmart because I didn't want to get in trouble, but I ended up getting in trouble because I drove off the parking lot with the person that was stealing. So I got charged with a retail theft, party to a crime. And I don't know what other cases he had or seen. I'm not sure. I can't even remember. But I got 3 kids now. Since the last case, I haven't had any more trouble. I don't have any DUIs, DWIs. Nothing. I just want to do bartending service because I'm a very friendly person, and I know a lot of people around Wausau. I've been coming here since 2008. I moved back home once I had my kids because I had no help. I was here staying by myself with 2 little children, a 1-year-old and a newborn. So I moved back to Milwaukee to be with my family. I completed my probation, and I haven't had I had a 3rd child, and I haven't had no more problems. I'm engaged now. Like, I've been trying my best to do all the right things, not because I have children, because I want to, go into a different path. I take my kids to school every day. I start CNA classes, but I just want to do the bartending because I like people, and it wouldn't be a nighttime, it'd be a daytime situation, and only on the weekend. So, but that's really basically.
Do you have, I mean, as far as
I have
evidence
my
of,
discharge.
well, evidence of rehabilitation, I guess, do you have paperwork that you could submit?
I could.
Because the committee also has the ability to defer action on making a decision for you until our next meeting, which is next month.
Okay.
And so,
Or until if Ben reviews it and changes his recommendation, then it doesn't have to come back.
well, that's true. So, yeah, I mean, if you have, the committee could delay action on this item and give you time to submit your paperwork.
Okay, so what they need, something saying that I've changed or from,
So
You're on.
did you get the letter? Looks like we sent it October 17th to the 3633.
yes.
Okay, so in there, actually, it looks like the second page of the letter, that's where it outlines the evidence of rehabilitation that the chief would consider. So one of the discharge papers, the probation, extended supervision, that stuff, and then the other 6 items that I guess are in our policy of nature and seriousness of the offense, circumstances related to the offense, age of the time, length of time since the offense, letters of reference, and then all other relevant evidence.
Okay.
So that's the second page of the documents that Mary sent you. So I just want to make sure that you had that. So all that's
I
then in
probably
there.
don't have it no more, but I know I had the time and date. Because
Okay.
I think I didn't open the letter myself. My fiance did because I was at work. I was working for WPS, not WPS, but Wausau Mailing Service. So I'm not sure. I know I have the front page to say come here.
Yeah,
I don't know if
second,
that was the front or the second page.
the second page has the list of rehabilitation stuff. I can resend you that
Okay.
if you don't have it anymore.
So why don't we, as a committee, if your committee is willing, why don't we hold off on this one? Give Mary time to send the letter to Cherish. If she has documents that she can submit to the chief, she can do that. And then at our next meeting, we'll have her back on the list. If we don't decide on her tonight, that gives us the ability to let him consider her papers.
Do you need a motion on that,
I
Madam
don't.
Chair?
You guys can agree by consensus if you want to wait. You feel like you want to just wait, give her the month letter, because actually it's like 3 weeks, because we're meeting later than normal. So it'll be the 3rd Monday of November is when we would meet again, our normal date. And that would give you 3 weeks to get your stuff in,
Okay.
if that would help. Now, does she submit it to the clerk or to the police department?
You can submit it to me, and I'll get it over to Ben.
Get it to them? Okay,
Okay.
so bring it into the clerk's office.
Okay.
Okay. And Mary, you'll send her the letter again? Like remail it tomorrow? Okay,
Okay.
perfect.
Thank you.
All right. Thank you for coming in.
Thanks.
Okay, also in the licensing item, we have a picnic license for River District. They want to hold a beer walk called Ale Trail, connected to Small Business Saturday in November. They've got their application in the packet, which looked similar to other things that they do downtown. Item 3, though, on there, Hauntingly Chill on Saturday, October 29th, 2022, was a collaboration between Matt's 101 Pub and Chatterbox. And so they were requesting that they do a block party, close Elm Street between their 2 businesses, and they had requested privileges for alcohol on the street. So I had asked Nate to look at this, because obviously if we can help them do it, we want to do it. But we have some problems with 2 licensed premises when alcohol goes between the 2 across the street. What we think, Nate's done some research on this, and what we need first, I think first there's an exemption that we could use that requires a 60-day advance application, right?
Yeah.
And so then at that point, my hope is that we could use the same enabling provisions that we use for dining on the street. that allows those businesses to temporarily expand their premises to serve out in the road, and then, that privilege then goes away at the end of the event. So, down there, we allow it weekly. This would be like a one-time deal. The thing is, though, is I don't know that we have the time to get the exemption created. This thing is coming up this weekend. Like, based on the guidance that I got from Nate today after his research, it appears legally that we cannot enable it this year. But if the same event were to come together next fall, and I think maybe one thing we need to look at is, because both premises are licensed, they're both in the River District. Do we need, because River District actually is the license holder for the dining in the street event, right?
The line is right there. Chatterbox is in the River District and Matt's is not.
Matt's is not? Okay, so, but, that I guess is a question that we would have to consider is if River District is the applicant for the event permit like they are for dining on the street, would that allow us to use those exemptions for an event next year? They're not engaged in this now.
Yeah, and then the other the bigger issue then is the potential for the alcohol to cross the premise. So as I guess we talked about at a previous PowerPoint, we can grant, temporary extensions of the premises for, various little events at bars and as such. The problem is that then when you take then that beer off the premise, one, that's a no-no, you have to consume on the premise and you don't then take anything off. But if you take it off the premise and then you walk onto another premise that's also then a bar, Wisconsin law does not allow that. And so the fact that they want to have a block party kind of defeats the purpose, because we'd basically have to say, okay, you're having a block party, but then here's the wall, because you guys can't commingle, basically, because we can't ensure that beverages aren't going back and forth to
Across the thresholds.
the imaginary threshold of this premise. So to me, that's the bigger issue of, I don't know if we can even allow this to happen. The laws and our policies and the special events and our ordinances were all basically just contemplating a single bar or tavern applying for, I guess, this temporary extension of the premise. It doesn't talk about if two want to go in together. And this is also then different for the dining on the streets, because we were very specific and very clear to give restaurants different abilities than bars and taverns. And so that's really where we're at.
Well, and that's, I guess, the question with regard to a block party. And then, assuming that I get the going into the other establishment type threshold situation. What if the entire event is outdoors? Like, I'm thinking,
Dan is here if you want to ask him.
okay, Dan, come up and talk to us about this event a little bit. I know Matt's out of town, so.
Yeah.
It is great to see you guys wanting to work together down there. I love the concept of this. We're just trying to mull our way through the legalities.
Yeah, and it's not really a block party per se. That might be a term that was thrown around, but it's more of a pub crawl between the four bars in the neighborhood. And we were just trying to provide a safer crossing of Elm Street between Matt's 101 and Chatterbox. So,
So neither, I guess, if neither party is serving outdoors,
nope.
and if it's a pub crawl, which they have them downtown all the time, and so, and not standing in the street consuming, let's say they come to your place and they get their card punched, and then they go to his place and get their card punched, like, typically those events, and then they're not standing out in the road, is that,
Yeah, then that's, as long as, again, that whatever is purchased on that premise is consumed on that premise and then not taken past the threshold.
and not taken out in the street
Yeah,
and over to
I mean,
Matt's. I guess that's,
Well, that was part of the hope, was to be able to allow them to cross between Matt's and our place, so people aren't slamming drinks
Yeah.
down to get there, because this is a timed event. So you have 1 hour at each place max, and then the groups keep rotating.
right. Well, and you both have outdoor areas that lends itself to that type of activity, but
Yeah,
the
no, as long as it's
street
contained.
closure, I think, is where we have the trouble, right? Right for now, with the flow between. Let's say they each conduct the same event, but they're conducting it essentially separately. I think when the downtown bars do it, they all have, people make the round, but I don't think they're carrying intoxicants with them. They're consuming, then they go to the next place, they get their card punched, they consume.
Yeah,
a-
and that's what you're saying
It's
then,
not like a
right?
beer walk or a wine walk.
That they're not taking the beer outside.
That was never our intent that they would be taking it with them, but this has gotten a lot bigger than we anticipated. This started, we were thinking we were going to get 80 people between the 4 bars, and we're probably pushing 200 now, which is great that there's interest because it's not just about drinking. There's a lot of events that have nothing to do. You have to bring a non-perishable food item as part of the activities. Tip your bartender $5. There's just a lot of different events. Some people that don't even drink are going to be participating. There's a costume contest too. But when you're crossing that close of a distance right across the street, and it's kind of a busy road, that it would just be safer. And it'd be kind of cool just to have that concept that you can just walk and there's no cars.
No, and I guess I don't have any issue with the street being closed. I mean, that's a whole separate part of this to me. I think engineering approves
Well,
those.
as part of the special event, the
Yeah.
street, if you approve the special event application that they applied for, you can do everything you're saying. We're just talking
Yeah.
the extra thing about the alcohol, but they had to apply for a special event because they wanted to close the streat. So that's
Okay.
part of it.
Okay, so then assuming we would approve it without, I mean, even if the street's closed for people to get across to and from, our request would be that we ask them to keep the alcohol. I mean, people need to either consume it in the bar or in their outside area and not be running around in the road with it, right? Is that
Correct.
where we're at with the law?
Yeah, because according to our ordinance too, the temporary outdoor of the bars and taverns, it only then extends to the sidewalks that are within their view. I don't, when I
They each
read.
have a back area though outside where people can be out,
Yeah,
fenced, you know?
so that would be then considered their premises. The sidewalk is not technically your premise, it's right of way, and we've allowed them to extend to the sidewalk absent any parking lot that they own. But then since I think we've established that it's the sidewalk, the street is not part of a right of way that we're allowing them to extend into.
What hours were we talking about, Dan?
2 to 8.
Okay. So afternoon and done early, so,
And so I guess the other thing too is, then the onus would be then on the specific bars of making sure that your attendees are complying with, I guess, our requirement that anything purchased is consumed on premise.
Are you having music? Because I thought I saw that in the app too. Is there going to be outdoor music?
No, it's all indoor.
Oh, it's indoor,
DJ.
okay.
We have a DJ. Other bars are doing different things. Matt's got a DJ, I think, as well,
okay.
but that's inside. His beer garden is just almost done.
Because I guess the thought, because this year time is so short, part of the trouble is we don't have a whole lot of time to mull what tools we have to even enable this. I'd like to find a way for us to be able to, I mean, when we think about dining on the street and the fact that you have jalapenos, lemongrass, chow, and Politos all together, and they all have these outdoor privileges, the idea that somebody could walk from one to the other is a realistic possibility. And yet during the event, because it really operates as like a Main Street type event, that has not been a problem. It's just, it's limited in time and scope. And so my hope was that we could find enabling provisions to do these collaborative events, but we need some time to like work through what that takes, right? So where we're at today is we could approve the event and the street closure, but they'd have to post no alcohol beyond this point at their doors like they would operate any other day of the week, right? I mean, at least for this year.
Yeah, and most likely going forward unless we change our ordinance to allow into the street. But then again, it could only go so far because then once the imaginary premise line is then
Right.
been drawn and you can't cross it.
Right. We'd have to have, and I mean, there's some gray area there. I mean, it's hard to recognize somebody outside with a cup. If you give them both
Yeah.
street privileges and somebody is standing squarely in the middle of the two, it's going to be very difficult to tell where the cup came from. So, I mean, we kind of have to be realistic about that too. But I think that, for this year, even if we were going to have an event permit type event and try to enable it the way we've enabled the other stuff, I think we need some more time to pull that together. I don't think we can pull it together in 5 days. Doug?
just a thought. I know if you go to a Packer game, they have a similar thing. People are traveling between establishments. But if you walked out of a place into the yard or into the street and then tried to come back in, you're not allowed. You're stopped at the door. You can't bring a beverage into their premises, which is our current
So you
ordinance
can get out,
anyway.
but no reentry, basically.
Correct. So now you eliminate having to determine, hey, did you buy that here or not? You can't bring it in. And I think that's a standard ordinance anyway. You can't bring your own beer into an establishment.
Right.
That's state law.
It's a state
Yeah,
law.
yeah.
So that's how they
However,
work around it.
at Packer games, you can walk from your car down 4 blocks to Lambeau Field, right through the city streets carrying a beer, and nobody says a word.
Right. But you can't carry it into an establishment.
Right, you can't walk to the bar with it.
So that's where they kind of police it, if you
And
will.
we would never let somebody, other than in this situation, carry a drink into our
Out,
bar.
or, yeah.
Yeah, in or out. We have the sign posted already that says, no open beverages past this point. It's just the special event, we're trying to not have people slam beer to finish to get to their spot. That was the whole goal. And there's only the 2 of the 4 bars that are participating in the street closure. So,
So under that circumstance, let's say that we would, right now, we don't have an application to amend either premise to allow the outdoor. But let's say that happened, and then they, in the course of conducting the event, did the no reentry policy, where once you're out, you stay out. I mean, if you're going to come back in, you come back in without a cup. Would that work? Is that something we need to research a little bit? Because, I mean, whatever's happening in Green Bay is happening on a way larger scale, and this is on a way smaller scale. So, it's always been our goal that if we have a tool we can use that would enable something like this to happen safely, we want to use that. It's been successfully working since the pandemic on the extensions that we've given for the summer and whatnot for sidewalks and parking lots and whatever. But I think, do we have to pull something together to make that work? Chad, do you have a question?
Is one of the big concerns 2 establishments going in?
Right.
Together? So
The cups from the one will walk into the other.
Right,
Because
but-
that violates their license.
But if just one applied to extend into the street?
we had this a couple years back. We had, when they ripped up Second Ave, we
You
closed the
did
streets
have a
on-
street thing out
Yeah,
front, didn't
we had
you?
a band there.
Yep.
But what happened then is they had to bring in these fences, and it was a show to watch these guys set up all the fences around to make sure that nobody could come in or out unless it was through a gated area where we had to have people checking IDs. And it rained, so that was just a waste of money.
Oh, geez, yeah. Well,
was a
and that's
waste of
my
everybody's
thought
money.
really, is if the street's closed in the first place, the whole thing is about delineating like where the premise is, like when you are in the right place and not. And so if the street's closed, that kind of eliminates the orange fence crisis. But,
And for people to participate in this, they had to prepay, and they get a wristband, and, they get a cup. So it's not just anybody walking in off the street that should be going from bar to bar to bar.
Out of curiosity, what are the other 2 bars? Because I only knew it was 101 and you guys.
LT Club and Callan Street, so it's the 4 in the neighborhood.
Okay.
And there's not a lot of activity going on at those other 2 places. Matt and I thought we should try to do something to get something going on the west side. So,
well, I like the idea of the collaboration, I think. So let's, I guess, discuss the possibility of if one were given street privileges, does that even solve it? No, because, well, I mean, in theory, they both could have, as long as people aren't coming back in with a full cup. With whoever's re-entering is going to have an empty cup, right?
Yeah.
But does that get us where we need to go? I mean, for even a temporary premises amendment for the both of them, would we need paperwork? Obviously, right? A request for premises amendment, that's not been submitted for a temporary amendment for the day? Do we have that ability? I mean, let's say they'd file for a temporary premises amendment for one day for those hours, each of them. And we have the understanding with them that they don't allow the reentry, because if that works, could we get where we need to go? What are your thoughts on that, Nate? I mean, if we would approve it contingent upon a single event premise amendment request coming in from the both of them, we don't have another meeting before this happens.
Yeah, so I think we would need the extension to show the sidewalk that they want to do, but absent that in our ordinance, which actually expires on the 31st, because it's just the temporary thing that we've put in place.
Right,
And then we'll have
summer
to-
only.
And we'll have to then look into it to see if we're going to extend that, going forward.
Right, well, we've been doing it year by year, but yes.
Yeah. Absent that, the street is, to me, is still off limits. And then the passing of the alcohol is off limits. So I know you said that you didn't want them to slam it at your premise, but I think it can't, they can't enter another business with the alcohol. So they're going to have to slam it either inside or on the sidewalk, based on, I guess,
Or
my,
consume it or whatever, but.
yeah.
Well, the spirit of that rule is to protect the bar from people bringing in their own product,
Yeah.
right?
Right, right.
And we're working together with Matt we're not being greedy here. We're not worried about the total sales of the dollar here. So the spirit of the law, right, is to protect us and get the sales that we deserve. We're just trying to make it a safer environment.
No, and I completely
Well, I think the
understand
spirit
that.
of the law too is about the control of the substance that gets sold. So if people are bringing stuff into a licensed premise from elsewhere and you don't know where it came from or where it was distributed from.
Sure.
Because you have to buy from a licensed distributor only. And so if somebody is bringing in their, coffee mug of whatever from home, you don't know what's in there or where it came from. And I think it's more about the control and there's probably a safety component too, but.
Yeah, and at the end of the day, we answer to Rick and the DOR for alcohol enforcement and compliance.
Well,
and
that's the thing. I mean, we
that's-
certainly don't want to run afoul of them, but.
No, so I always have that. There's always somebody, I guess, watching over anything I say, I feel like, for anything alcohol
While you're on
related.
TV,
And so I guess that's where I'm at with it. As long as, I guess, the alcohol can be, I guess, confirmed that it's not
Crossing between.
crossing, I think we are okay, contingent on, I guess, an application to show
So we
that
meet the date
premise
requirement
is
because we're before
extended.
Halloween, so we're good on the 29th. And so then they would each have to submit an application for temporary premises extension for just that day, right? And then we would have to, if we issue the permit for the event, it would be with a clear understanding that the cups would not be allowed to re-enter, like Doug described. If you go out with a cup, you stay out until your cup's empty. That's what they'd have to watch for.
Yeah, because you guys use different colored cups
No, everybody in the whole group is getting the same cup.
in the same cups. That's
Okay.
what I was thinking. Okay.
Note for next year.
Yeah.
But one gets red, one gets
Hauntingly
black. Or
chill.
one gets orange, one gets black.
Yeah, hauntingly chill in a variety of colors. Collect the whole set.
Right? Yeah, collect all four. Okay, so could we approve it contingent upon the clerk's receipt of the temporary premise amendment
Yeah, and then
documentation?
Mary would then let them know from there if she needs more information.
Okay. And now, just with a quick circle back to the chief and the deputy chief, do you believe that with those provisions that we could safely manage this event if they close the street? They're nodding. I think they think it'll be okay. I think we've got two responsible owners. I mean, we've got good track record there.
Thank you for that.
So you guys do it right. There's no question about that. Okay. So that said, is there a motion to approve the event contingent upon the clerk's receipt of two applications to temporarily extend their premise to allow for this event on the 29th?
I would move that we approve this event as described, but does this also include all of the licenses?
Well, we'll take this event separate. I think
Got it, okay.
this is a big enough one that I think we should take it separate. And we didn't act on Cherish, so we'll do the
I would
batch
move
next.
that we accept it as described.
Okay, so we have a motion from Denny to allow the event contingent upon the receipt of the two applications to temporarily extend their premise outdoors on the 29th during the hours that are specified, 2 to 8. Is there a second?
I'll second it.
Second from Larson. Further discussion or questions? Members in favor signify by saying aye. Aye.
Aye.
Opposed? None are opposed, so that motion carries. Okay, so you're good on that. As long as you don't allow the reentry, you should be okay. And then each of you submit that application to Mary
Stop and talk to Mary.
before the end of the week. So,
See you tomorrow. Thank you.
All right, thank you for that. Now, we've got the rest of the batch of licenses. Do we have a motion to approve the rest of the batch with the exception of Cherish Winfrey, who we're going to take next month? Motion from Henke, is there a second? Second from Denny. Further discussion? Seeing none, members in favor signify by saying aye.
Aye.
Aye, opposed? None are opposed, that motion carries. Okay, so we are to the point where we have run out of time. I mean, we had some great discussion about alcohol and events, but I feel like we're going to have to hold the presentation that was item number 6, because we have finance starting in 5 minutes. And then we'll also hold 4, 5, 6, 7, and 8, if that is agreeable to the committee. And I talked with the deputy chief prior to the meeting. We were unable to have our outreach coordinator with us this evening. She had a scheduling conflict. So if we take item 6 at our next meeting, we'll have her with us as well. Is that agreeable to you guys? Okay. All right, so then we'll hold the rest of the agenda because there's nothing on it that won't keep. And with that, I'll take a motion to adjourn. Motion by Larson, is there a second? Second by Henke. Further discussion? There never is. Members in favor signify by saying aye.
Aye.
Aye. Opposed? Nobody is. We'll stand adjourned then. Thank you, everyone.